Keynote speaker is Henrik Ringbom. Henrik, please, well known to me, a friend and a leading academic who really has been playing a significant role in the academic response to mass and how to address the problems that will arise. So, Henrik, I'm sure we're all going to benefit greatly from listening to you.
Thank you very much, Fridian, and thank you to the organizers for allowing me to be here. It's very nice. First time. Already enjoying it very much. I thought that the keynote speaker was supposed to speak a little bit shorter, but now I have discovered that in fact this keynote speaker is in fact supposed to speak a little bit longer, which is no problem. I will probably try to leave a little bit.
That's an advisory.
Yes.
But
I will do so. But another thing I think the keynote speaker should do, which I will not change, is that I thought that maybe a keynote speaker is to talk about the matters a bit more generally and probably raising questions rather than providing answers. At least this is what I thought to do. And I will overlap a little bit with what things that have already been said and things that will be said. But on the other hand, I will try to do it in the form of sort of raising issues rather than solving them. Basically, the two main questions I will address are quite fundamental. The first one is, are mass lawful in the first place? And then secondly, what if things go wrong with mass? Who pays? These are, of course, completely crucial questions in terms of the regulatory challenges linked to mass. But the nice thing with mass, compared to most other topics in maritime law I've been involved with, is that it cuts across the whole field of maritime law. This is a thing I usually show to my this doesn't move forward now. Maybe there. Yeah. This is a little table I show to my students in the beginning of the maritime law, is that we have very different types of maritime law. Maritime law is very many different things, and it's regulated in very many different places depending on what type of maritime law. We have some jurisdictional rules that are only regulated at global level by the Law of the Sea Convention. We have technical rules, mostly IMO. We have liability rules, which are a little bit more scattered. And then we have regional layers, and in the Nordic states, we have the Nordic layer, where the main maritime code is common to the Nordic states, and of course, national. So mass actually impacts all of this. And that is makes it so fascinating, because all these silly borderlines between private law and public law, and I do insurance and you do that, etc. They are sort of in a way gone when we talk about mass, because we are all interested in mass. We just have different perspectives to it. And the perspectives I'm going to talk about are mostly the ones over there. It's the international regulation, the global regulation, which means that the two questions I had will raise three different types of issues. It is law of the sea and IMO rules. And then the second question will deal with liability rules. So in a way, the question whether it's lawful or not involves both the law of the sea and the technical rules of the IMO, whereas the who pays for accident question deals with liability rules, which are non-existing at the moment, but if there are such rules to be developed, it will probably be within the IMO as well. So there are, of course, many different types of legal questions that can be invoked in all these 3 fields, but I have decided to select one of each field to study a little bit closer. Partly because of what is topical right now and what are the discussions that are interesting at various international organizations and academic communities. The first question is, I choose from the law of the sea. It has to do with this remote operating center, the status of that, and in particular the law of the sea issues linked to that. And I apologize in advance for a little bit stepping on tomorrow's speaker's toes there, but I couldn't resist. Anyway, I'm not going to answer the question anyway, as I said. When it comes to the IMO rules, we have heard already quite a comprehensive overview of various things that the IMO has been doing in this field, but I was planning to say a word or two on the MAS code, which is now, since Friday, there is a new draft available and it's making progress, and a little bit of the legal issues linked to that, which are not really addressed in the code, I want to highlight. And then thirdly, on liability rules, we already heard about that as well, but the question I want to look at very, very quickly is whether there is a need for a new scheme. Is MAS so different from other ships that it somehow would justify a separate liability regime? Or could it be treated like any other technical error that we have been able to cope with in the liability regime so far very well? But before I start with the law of the sea question, let's make some things clear from the very beginning. First of all, I depart from the assumption that MAS are ships, vessels, within the meaning of law of the sea, and I think this is not so disputed, even if we ignore the really small crafts. This is, I think, I mean, what else would they be? So they are subject to the same rules and obligations and rights as other ships. But also we have to bear in mind that MAS is not the same as unmanned ship. A MAS can be manned, partially manned. There are various type of gliding scales here, both when it comes to the manning aspect, and some of the problems, legal problems related to MAS, start already when you remove the first person from the bridge. Most of the problems arise when you move the last person from the bridge, but some of them arise at an earlier stage, and therefore one should keep this in mind. And the same goes for the sort of grayscale when it comes to automation. It is not about fully autonomous ships or manual ships. There is the whole gray zone in between about increasingly automated ships and maybe it's a operation which is based on the computer completely, but then expect some sort of human response when an alarm goes or whatever. All these things, that's normally where the legal interesting areas is in the sort of grayscale areas here, and if you just do it like the IMO did in the beginning with these 4 areas, you lose all that gray zone because you just deal with category 3, which is manned, and category 4, which is not manned. Category 3, which is not automated, and category 4, which is autonomous. So this leads me to another starting point, which I believe is important, which is that MAS does not represent a new category of ships. And this is super relevant when it comes to regulation of MAS, because we are not dealing with a completely new entity, which is there, comes from nowhere, and is supposed to coexist with existing ships. It is just ships that are being used operated in a different manner than we have done before, with the aid of technology, much more aided by technology that than we are used to. Which means, of course, that the mass can be a mass part of the time and operated as a non-mass part of the time. In fact, depending on how you want to define these matters, a ship might shift between mass and non-mass several times during a single voyage, which is, of course, a nightmare for anybody who wants to regulate mass in an orderly fashion through an instrument. So this type of issues need to be borne in mind. I don't think even the mass code, as of now, has really decided on this question on how to address this sort of very operational element of the mass, that it shifts. Okay, going to the law of the sea. That was my first field that I wanted to explore. Of course, there are many key questions when it comes to law of the sea and mass. Some of them are listed here. A very important dividing line is, of course, what IMO has done in field of mass. Because if IMO approves mass through its own instruments, the law of the sea changes radically, because the law of the sea, in a way, incorporates IMO's rules in what is required and what is lawful, etc. So there is a big difference on what questions are relevant before the IMO has regulated mass or part of mass, and then afterwards. But the one question that I want to look at is in the first scenario up there: can a state authorize mass to operate under its flag? But a sub question under that, which is what about this remote operation? All these obligations that flag states have, in particular under Article 94 of the Law of the Sea Convention, how can they be met if the ship is operated remotely, and in particular if it's operated remotely from another state, which is likely to be the case very, very frequently. So here we have some of the key articles that in the view of some create problems. Every state shall effectively exercise its jurisdiction and control in administrative, technical, and social matters of a ship's flying its flag. And in particular, they shall assume jurisdiction under its internal law over each ship flying its flag and its master, officer, crew, in respect of administrative, technical, and social matters concerning the ship. So can the flag state effectively exercise jurisdiction over operation that takes place in another state? Or can it even effectively exercise jurisdiction to remote operations in its own state? We don't know how accessible they are either. And do flag states currently effectively exercise jurisdiction of this type of operational matters of ships under their flag? I'm not so sure. So the scenario here, which I wanted to look at, is where the flag state and the remote operating center is located in different countries, because that, of course, changes many things. You need to decide, for example, what conventions apply to that ship. Is it the ones that the flag states have ratified, or is it the ones that the remote operating state has ratified, or is it both? My answer to I promised I said I wouldn't provide answers, but this one I will answer anyway. I think it's clear that it must be the flag state's obligation that still guide this, because the whole point of this exercise cannot be that a flag state in a way avoids obligations that it would otherwise have by outsourcing operation. So what are the starting point is that, or should be that flag states duties remain the same. And it's the flag state that has to ensure that all its obligations are met. But of course, if a ship is operated from another state, there will be things that the flag state cannot control, like the security of the building, all sorts of criminal law things applying in that state. Maybe they have other corporate laws completely. And how is the flag state supposed to deal with those kind of challenges? And I also mentioned the prospect that there may be completely different treaty obligations. Some have even said that this is a problem from the point of view of the genuine link, the requirement that there has to be a genuine link between the flag state and the ship. And therefore, if operation is undertaken from a different country, that link might be broken. And people who have this type of concerns come to the conclusion that the remote operation then should be taking place in the flag state, because through that there would at least be the jurisdictional control over the operations, including all those things that I just listed that might not be otherwise. But I think, without answering any of these questions, I think it is very useful to look at my next picture, just to bear in mind what we are talking about here, not to make things overly demanding compared to the current situations for remote operating centers. Because if we separate the level of the state and the level of the corporations, the companies, and the individuals, it looks something like this. We have the traditional operation of a ship here, and we have a remote operated ship there. And we all know that we have had very, very little requirements on flag states to date. I mean, the ship owner is, of course, a much more important person than the remote operating center by any standards in the sort of chain of responsibility in shipping. There are no requirements on territorial presence of a ship owner currently. You can register a ship which is owned by a company anywhere, and it can be crewed by anywhere. It can be, master could be from anywhere, etc., etc. So why then, for this particular category of ships, would you be so incredibly keen on maintaining those rules? Another thing is that the genuine link requirement, for example, that is not that is a link between the flag state and the ship owner up there, a link which is not in a way distorted by this remote operating things, remote operation of ships. It is we are not changing the basic structure, the main responsibility which goes from the flag state to the ship owner to the ship itself. Instead, we have a new entity that had somehow to be accommodated in this new, and there are various discussions on how that can be achieved. One sort of buzzword in this context has been the ISM code model. I think what is referred to by that is the idea which was implemented when the ISM code was introduced in the 1990s, is that you could actually exercise jurisdiction over the ship owner or operating company through the ship itself. The flag state could put requirements on the company wherever it was established, and then in order to be registered in that flag state, that company had to comply with certain duties and safety management measures, etc. And I think that could be workable here as well, but it's not the only solution because it cannot address some of these problems. It cannot address, for example, the question of what if something happens and there is a criminal liability for the master of the mast who sits in that state. It is certainly not a thing that the company can regulate in a kind of ISM type arrangement with the owner and the flag state. This is something that needs to be regulated by the states themselves, interstate agreements on extradition or whatever it can be, this type of interstate question. So there may be many types of solutions available, but I always think it's important to bear this picture in mind, so not to confuse things too much about and placing unreasonable amount of conditions on a remote operating state compared to what is currently the case. Of course, you could also take the view that this is a golden opportunity to put some meaning in this effective jurisdiction of the flag state and genuine link, etc., and use this as an opportunity to move in that direction more generally. But I don't think that has been openly presented as the reason for this argument. So I already mentioned these these three types of or two main types of solutions that could be tools that could be used for addressing this. But I think it's clear that in any case the remote operation center in a different state does involve a kind of a further evaporation. We have seen an evaporation of the flag state's responsibilities and effective controls ever since the 1950s, at least. And I think this is one more step in that direction. But well, no, I should not answer any questions, so I stopped there.
Very professional.
It's only out of respect to the speakers that will speak about the similar topics afterwards. But then moving into from the law of the sea questions to the IMO questions, we already got a very nice overview of what IMO has done. It started with this regulatory scoping exercise, which was a completely backward-looking exercise. It was only looking at how would this new type of ship operations fit into the existing rules. It did not address the question of how to accommodate them, how to deal with the problems at it. And there are a number of main issues that could be identified when you start looking at the existing conventions from this perspective. And for a long time, there was not much action, but now basically the only thing that happened was that there were some, at a very early stage, there were some trial guidelines accepted in 2019 by the IMO to cater for mass trials. It's a very interesting document, but it seems to be not implemented to its full extent. In fact, the IMO itself seems to be a bit confused about this whole mass trial question. There was a discussion this spring in the Maritime Safety Committee about using an exception in the STCW Convention Regulation 113, which allows for tests for only one person on the bridge in certain situations. And the question was raised by somebody that can we use these exceptions for testing mass, which one would have thought would be obvious. If you can talk about 0 persons on board the bridge for testing, why shouldn't you be able to test with one single person? But the committee decided that we need to look closer at this matter, and they will come back to an answer to that question later on, which just indicates how ambivalent really the situation is with respect to mass for the moment. No, not more about them. Instead, what is really interesting and important and relevant is the technical work that is happening now in the field of the mass code, which was also already presented. The idea was that it would be finalized next year and then mandatory in 28. At least the second date is now very unlikely to materialize, but at least there is work going on with finalizing this code. I will come back to that in a minute. The legal committee has discussed some UNCLOS issues, but also a first discussion on the liability question, mainly through this CMI paper that was introduced this spring. But the response to that question was that it is a very interesting and useful analysis of the various complications involved, but it comes a little bit too early. Let's not involve in this type of questions at this stage when we don't even know really what type of mass we have regulated from a technical point of view. So let's come back to that later. And then there was a joint working group involving all the committees that made some important principles, but also I think very, very maturely decided that now we have done what we are supposed to do, what we can do. Let's put our work on hold. Let's not meet again because there are we don't have so many important things to discuss anymore. And I think that is a very wise decision by that joint working group. So it's no longer active, but it might activate itself again. So by far the most important one and the most energy has gone into the mass code discussion. That is the name of the document from last Friday, which those of you who have access to IMO documents can have a look at that. It is the state of play of the code. It's already something like 65 pages, the code, and there is a lot of, there are only 2 chapters out of 28 that have been completed now, but there are sort of draft texts and proposals for the others. It deals with all sorts of interesting things, such as risk assessment and navigation, safety of navigation. That is one of the chapters that has been finalized now, and fire protection in onboard mass is another one. But it deals with, it has adopted this approach of the Polar Code and some other technical rules of a goal-based, that is starts off with indicating the main goal of the rule and then lists certain expected performance criteria that has to be achieved to meet that goal, and then sort of includes much more flexibility into the technical regulation than we are used to with IMO rules. And that, of course, presents legal issues of its own. So if I look at the some of the legal challenges raised by this mass code, well, one of course is the status of this code. Clearly, if it's only a voluntary document, it will not change any binding rules. That said, I already referred to that STCW 113, which could be argued that even soft law instruments could be used, because that requires any tests with unmanned bridges to be undertaken in accordance with IMO guidance. Maybe this could be interpreted as one such guidance, I don't know. But at least the Law of the Sea Convention opens up for sort of legal implications of non-binding acts by the reference to generally accepted international rules and standards, which exists everywhere in the convention, including in the flag states obligation. And that is not limited to binding conventions. But clearly, the main impact of this will take place when it becomes a new chapter of SOLAS. and a kind of a new mandatory regime in itself. That doesn't mean that the legal problems are solved, rather that new problems will arise. First of all, we have the relationship to the normal ship rules within SOLAS itself, but also in other conventions. How is it possible that a chapter in one convention could somehow override rules in others? Probably they need to be amended as well. But also we have this compatibility with the temporal nature of mass. SOLAS is generally very focused on static things, and a ship does not change category from 1 minute to another, and this aspect clearly is something that will need to have be subject to some attentions. There are even some who have argued that this is going too far in making a new chapter of the SOLAS. The tacit acceptance procedure, which I think many of you know, which sort of amends existing rules by adopting a new chapter, and they become immediately in force for all the parties to the convention if they don't specifically object to it. So it in a way reverses the burden for it brings along the inactive states within the binding of, and SOLAS of course is ratified by almost all states. So it's a dramatic change maybe of the SOLAS convention to make this generally applicable through the adoption of a new chapter through tacit acceptance procedure, but some have argued that this goes too far. There are limits on how far you can take this tacit acceptance procedure. If you regulate things that are completely against what is in the rest of the convention, you cannot possibly do it in the form of a sort of simplified amendment procedure like that. There are not many who have advanced this argument, but it's an interesting one, and deserves to be looked at as well, I think. It has not been respected at all so far with when SOLAS has been extended to ISM code or ISPS issues or polar codes or whatever. But then we have this whole question of goal-based rules. What does it mean really in reality? In my mind, it means that it will be the classification societies who decide what are the real requirements, and then flag states will accept. And the classification societies might have different opinions on different. The whole question loses much of its, not only its stringency and clarity, but also transparency if the rules are going to be sort of, the detailed rules are going to be delegated to some other players who are not subject to the normal type of scrutiny that traditional regulators are subject to, even if the IMO is not known for being the most transparent organization anyway, but at least it's subject to some global administrative law principles, etc. So those are some of the legal issues raised by the new code, which haven't really been addressed to date, but I believe will come up. There are probably others as well, and I'd be interested to hear your thoughts about that. And then finally, liability rules. Ridian, what is my time situation?
How much do you estimate that you know?
I could do this in 5 minutes and I can do it in 15.
Shall we settle on 10? That's what they call legal negotiation.
So in contrast to all the other rules I have been talking about, these are not globally regulated for the moment. Most liability issues are not covered by international rules at all, and even those who are, they are not as widely ratified as safety rules or law of the sea things. So there are a number of that is starting point is different, which also means that these things are not as harmonized as safety rules, and there are greater variations from one state to another Of course, we have some harmonized rules internationally on pollution, damage, and passengers. Specific rules that have said that this sort of starting point regime, which is based on fault liability, is not sufficient. We need to provide better protection for claimants and strict liability and compulsory insurance and this type of tools. And then we have the Collision Liability Convention from 1910, which turns out to be quite important here, because many of the tortious liability cases actually relate to collisions. And these rules from 1910 specifically provide that the liability shall be linked to fault. So it would be a treaty law challenge as well to come up with a convention saying that mass collisions should be governed by strict liability, like pollution liabilities, for instance, example. As opposed to safety rules, and my first question, are mass lawful? These questions can be regulated a bit later. They don't have necessarily to be in place before you start operating the mass. But of course, it would be prudent to start discussing these things before we send out these ships to the seas, to know more or less what to expect if and when things go wrong, who is going to be responsible and who is not. Otherwise, there is a great risk that different countries and different courts take a very different views of it, and then it's much more difficult to harmonize later on once that has started. That was one of the bases for the CMI papers. So basically, there are two main questions linked to the liability here. One is, who is the liable person when it comes to mass accidents, and we have the normal the vicarious liability, that the ship owner is liable for a lot of other players. But the question is, okay, what about these people who are very far away from the normal activities of the ship owner? I mean, not the remote operator. That is clearly a very sort of traditional way of operating ship, that sort of activity that falls within the vicarious liability. But this sort of shipyards that install this equipment, or manufacturers, equipment manufacturers, or all these people who are very sort of, is the ship owner really expected to be liable for all the errors caused by those people as well? That, I think, is the question related to vicarious liability. And then the bigger question is then, okay, but what then is a fault? Because even vicarious liability requires some sort of fault. What is a fault in a situation where, in many cases, nobody could reasonably have understood that that the system is not working, or it's wrongly programmed, or whatever, or I mean, if you speak about remote operation accidents that are caused by a failing communication link, for example, is that really a fault by the ship owner or somebody under? And how do you really establish fault in a completely automated context? The first question about the vicarious liability is a traditional maritime law issue, but the second question is a more general question, which deals really with any type of automation liability. So it's similar questions that have to be addressed for cars and all sorts of AI risks. And then, of course, we have the question as well that will there be a need for new types of liability regimes in view of this, like product liability? We will hear more about that. But the question then is, do we need, would mass require a new type of liability instrument? And this is one of the issues that we analyze in this CMI paper. we analyzed different types of mechanisms, how we could resolve the various challenges that the new situation presents, and go through various action ways of dealing with it. One is not to do anything, but that is far from problem free as well, as has been identified. I mean, it is not. But if you go to the other extreme, there could be a strict liability regime where the ship owner of the mast would be strictly liable for any type of damage that is caused by the damage, and then through recourse actions and others, he could then or she could recover the money from the person. That is not necessarily problem-free either, even if it would be a convenient and straightforward solution, but because it would put the mast and the traditional ship in a very different and unfair situation if there is a collision between the two. One is strictly liable and one is not, and all the problems that brings about. But there are other solutions as well. You could have sort of go only part of the way. You could have this type of anonymous and cumulative fault, but that still requires some sort of fault to be identified. And you could also focus on the ship owner's negligence in choosing the relevant shipyard or choosing the relevant equipment, or saying that is a fault in itself, and have this raise the standard of care dramatically by this type of constructions. You can also have a presumption of fault. And then we have even they introduced the idea that maybe the mast itself could be at fault, like a sort of a defective ship. In some legal systems that is complicated. In others, it appears as an option. So these are the options. But I think what is relevant to note here before I finish is that all of these are very complicated when it comes to regulating these things, because of, again, what is a mast ship, and how do you have different liability regimes if depending on what mode the ship was operating in at the moment. You easily run into a situation where you sort of encourage ship owners to conceal that they are operating in a mast mode if different liability regimes applies for that. And so I think I will stop there. Let's see if I have some general concluding thoughts. Maybe this is my last slide. Coming back to all three themes and all three questions, it's a fascinating topic, basically, because really it cuts across the entire field of maritime law, and many key questions are still unanswered. I think that the law of the sea related questions, thanks to the close link between law of the sea and IMO regulation, can be resolved. You don't have to start amending the law of the sea convention, which is practically impossible, to allow this development to take place. But the role of the IMO, of course, is completely crucial in legalizing this, in particular outside the internal waters of a particular state. And the technical rules will change as well. They will be more dynamic, more goal-based, less clear maybe. And liability rules, I don't know what should be the outcome in that field, but at least there should be a discussion, because there seems to be a big misunderstanding based on the regulatory scoping exercise, which also included the liability convention, where states noted that there are not so many problems with the liability convention and mast. But that is, of course, because they are the exceptions. They are the strict liability rules that are subject to the convention. The normal liability rules is not regulated anywhere, and that's where the problem is. So this needs to be taken up at some point, and hopefully within the IMO's legal committee, maybe in a year or two. But it would be irresponsible to go ahead with much without any deliberation on that field. I think. Thank you very much.
Thank you.